Good morning, everyone. My name is Kevin Price from the Thomas Carroll Group. And first and foremost, I'd like to thank you for joining our employment law webinar this morning. I appreciate that you're all very busy at the moment, so we are extremely grateful to you all for giving up your time and listening in. As the government looks to ease the lockdown restrictions, a key priority for businesses will be to bring employees back into work. I think as the year unfolds, this in turn is likely to present significant employment law challenges for many organisations. So our webinar this morning has been designed specifically to address these issues and to provide some practical advice and guidance on how you can overcome them. Our presenter this morning is Roger Davis. Roger is one of our employment law specialists. He's a barrister and a board level director with Thomas Carroll. So Roger is well placed to provide you with the advice and guidance that you need. I hope you enjoyed the webinar. I'll now hand you over to Roger, who will take you through the presentation.
This is Roger Davis, Employment Law Director of Thomas Carroll Management Services. The seminar is to look at some of the employee issues around bringing an employee back to work with regards to the COVID-19 crisis, and also to look at some of the furlough changes which are due to take place from July this year. So, a little used area of law previously, and certainly an area of law where there is little current case law, is around the question of when an employee is allowed to refuse to work where there is a reasonable belief of serious and imminent danger. If the employee is able to show that they reasonably believe that they are in this situation, then they have a right not to be dismissed and have a right not to be subjected to a detriment. What I mean by a detriment is to be treated less favourably because they have acted in that manner. If the employee is able to successfully show this in an employment tribunal, then any dismissal is automatically unfair and compensation is uncapped. Clearly, that's a very important consideration for an employer. All the employee has to do is to demonstrate that they reasonably believed that they were in this serious and imminent danger, and that their dismissal was caused by them relying on their rights in this regard. You'll see there from the slide that the compensation, and this scenario is one of the few areas in employment law where the compensation is uncapped. At the moment, in very rough terms, an employee is only able to claim what would amount to their redundancy pay and up to a year's salary. However, in these particular circumstances, they are able to claim and be awarded whatever an employment tribunal believes is just and equitable in the circumstances. The other important thing to note here is that whilst there are many potential employee claims which require a minimum of 2 years service, this is one of those categories where there is no minimum service requirement. So in other words, it is a day one right. Employers therefore need to be very careful and take note of employees' concerns in this regard, as I'm going to demonstrate as we go through these slides, the rights of the employee are probably far wider than you might anticipate. So, as I say, this is an area of law, of employment law, where we've been asked many questions over the last few weeks, and I'm sure we'll be asked this many times over the coming months. So, what is the legal test? The definition of danger is an objective test. However, in the few cases that there have been, it has been widely interpreted. So there's a case of Edwards against the Secretary of State for Justice, and in this particular case, an employee refused to travel on a minibus to a prison where he was working due to the conditions on the road, due to snowing. And the courts indicated in this test that just because other employees were happy or agreeable to travel in those conditions, that therefore didn't automatically preclude Mr. Edwards from arguing that he believed he was in a reasonable imminent danger. Therefore, as I say, the test is perhaps much wider than you would consider. Therefore, employees in the current environment, where I think it's going to be very difficult to argue that COVID-19, given the number of deaths involved in the UK, does not reach that hurdle of being a serious and imminent danger. As such, the employer would be well advised to take any comments or concerns by an employee seriously, even though perhaps every other employee within the business is happy to return. Another interesting point on this is that the test potentially does not only extend to the workplace. So in other words, there potentially is the argument, looking at previous case law, that an employer will need to consider not only the areas of the working environment which it has control over, such as the shop floor or the office spaces, but it also has to consider the public transport to and from work. Of course, employers listening to this may well be thinking to themselves how unfair that is, because they have no control over the public transport. They're not able to have any control over whether to make that safer, or indeed any control with regards to the provision of that transport. However, as I say, like many aspects of law perhaps, it isn't totally about common sense, and as I say, case law does perhaps indicate that it will be extended outside of the actual immediate vicinity of work. Also worth noting and remembering that this isn't just about refusing to work. There could also be a detriment with regards to an employee who says that they have been told that they're not allowed to, for example, wear a face mask. So it may well be that the employer has taken a policy decision to say that face masks won't be appropriate within the workplace, but an employee decides that they wish to pursue this point in order to ensure their own safety. Again, we potentially could see some cases around this. finally, we just need to consider that this isn't just about employees who are refusing to come into work. It is about employees who are in work and they believe that they have seen something which is of serious and imminent danger, and they then elect to leave the workplace. Those of you who have been avid readers of the government guidance will note those particular words, serious and imminent danger, and certainly those are words which have been used in government announcements and guidelines over the last few months. So, as I say, what is a detriment? One question we've been asked a lot of is, if an employee refuses to work, then can they just be told they can remain on furlough? That seems a sensible option, which hopefully will ensure the happiness of the employee, but also maybe something that the employer can live with as well. That said, because the furlough scheme is based on 80% of earnings and not 100% of earnings, then the employee in theory could still argue that they are still subjected to a detriment because they're earning 20% less than they would have if they had been in work, and they would have been in work if there wasn't that serious and imminent danger. Where furlough isn't an option for the employer or the employee, so for example, where perhaps the furlough scheme in the future has come to an end, or indeed perhaps for whatever the reason the employee has not been furloughed to date, and only since then the employee has raised the issues around health and safety. It's a grey area with regards to whether an employee can argue that not being paid is a detriment as a result of them raising a health and safety question. There's a very fine balance between an employer arguing that the reason that an employee is not being paid is because they are not in work, and the employee arguing that the reason they are not being paid is because this was linked to their health and safety concern. It was only as a result of that health and safety concern that they're absent. As I said at the beginning of this presentation, this is an area of law which has had very few cases and has not been subject to a tremendous amount of case law. I think it's probably fair to say that that will change over the coming months as employees perhaps consider this option which could be open to them, particularly given that if they're able to get over the hurdle of showing that they're covered by the legislation and their dismissal or detriment was caused by that, then, as I indicated earlier, it's going to be an automatic unfair dismissal with potentially unlimited damages. The other point perhaps to note here is that the serious and imminent danger does have to be a reasonable belief. And of course, the more that the employer has done to ensure the health and safety of those working within the business, and the more steps that they have taken, then the more likely that the employer will be able to show that the belief of serious and imminent danger was not reasonably held. So, some practical solutions. I think key to all of this, as is the case with the majority of employee-employer relations, is good communication and consultation. ACAS gives some pointers with regards to the effective way to bring employees back into the workplace, and they talk about giving the employee notice, engaging them in good communication and consultation, giving them reassurance. The more reassurance that the employer can give, the less likely it can be shown that there was a serious and imminent danger. This presentation doesn't deal with health and safety, but clearly effective and detailed risk assessments and acting upon those risk assessments is going to be a key factor for the employer, as is ensuring that employees are aware of their obligations with regards to social distancing, with regards to the public health guidance around hand washing, etc. The employer could also give consideration to continuing with home working, and that's still the start-off option, and also to consider perhaps staggered starts, so employees are not all arriving at work at the same time, and perhaps they're not using public transport at the height of rush hour. In addition, it may well be for a short period of time that employers are able to provide transport to convey employees to and from work, although of course that would bring its own health and safety issues. The other important point is that, certainly from an employment law context, it isn't sufficient just to ensure that employees are aware of their health and safety obligations. The employer also has to ensure that they are adhered to, and this may mean that employers will need to take disciplinary action where employees are flouting the health and safety requirements. Certainly, if the employer looks the other way, then that will give ammunition to the employee who is arguing that their workplace is a dangerous place to be working. The other issue, which has cropped up on many occasions over the last month or so, is this question about employees who are asked back to work, but they are classed under the government guidance as either vulnerable or extremely vulnerable employees. There is always a balance to be struck between the needs of a business who are looking to restart production, restart providing their services, and the requirement for employees to return back to work. However, I think it's probably fair to say that the law in this regard is going to be stacked in favour of employees. So, if an employee is classed as vulnerable or extremely vulnerable, and in particular if they've received a letter from the government confirming this, then it is going to be very difficult for an employer to compel an employee to return to work contrary to the official advice they've been given. In addition to that, it's very likely that an employee who has been given one of these letters is also going to be covered by the Equality Act with regards to disability discrimination. As such, the employee who is being told, or perhaps even given an ultimatum to return to work in these circumstances, will have the option of claiming disability discrimination and staying within their employment or leaving their employment, and also potentially will be able to claim constructive unfair dismissal on the basis that the employer has not acted reasonably. Also important to note, of course, that the usual 2-year rule does not apply where employees are claiming discrimination. Also, again, similar to the health and safety issues we spoke about earlier and the legislation around that from an employment law perspective, compensation for discrimination is also uncapped. So again, I think the clear advice is that employers are not going to get, or shouldn't expect to get, much sympathy from an employment tribunal where they're taking a hard line with regards to employees who fall into this category. The other area which we've increasingly seen is around this question of associative discrimination. This, in effect, is where an employee is refusing to return to work, or perhaps is refusing to undertake some elements of the work, not because they themselves have a disability or a particular illness, but where they are perhaps living with someone, they have a partner or husband or wife or children or elderly parents who they are living with, who would be covered by the legislation. In other words, that individual would be covered by the Equality Act with regards to having a disability. Under the Equality Act, there's a protection for employees who are able to bring a claim of discrimination based on their association with somebody who has a disability, even if they do not have that disability themselves. I perhaps won't go into the technical reasons why. However, this is a difficult claim to bring, particularly because the key area around this element of the Equality Act relates to direct discrimination, and an employer in many circumstances will have a defence to this. However, there is certainly real scope for an employee in these circumstances to allege that the employer has not acted reasonably, and this unreasonableness has led the employee to resign and claim constructive dismissal. To do this, without the element of discrimination, they would need to have 2 years continuous employment. I think it is likely that employers will struggle to argue that they have been, they've acted reasonably if they take a tough line with employees in these circumstances, particularly for larger employers who will be expected to have the resources to be flexible with regards to employees. It might be easier for smaller employers to argue that they have done all that they can and they have acted reasonably, but again, it's not something perhaps which an employer could feel confident about. From a practical perspective, an employee bringing a claim in this regard, given the backlog in the employment tribunals and the fact that they've been put on hold due to COVID, is not going to see a resolution, I would imagine, for at least 12 months. And perhaps that alone will encourage an employee and the employer to negotiate and consult and try to find some happy medium. The final point, as part of my talk today, is to talk about the flexible furlough scheme, which is being introduced from the 1st of July. So, from the 1st of July, employers are able to bring furloughed employees back to work for any amount of time and any shift pattern, but will still be able to claim from the coronavirus job retention scheme, i.e. the furlough scheme, for the hours not worked. There was some confusion earlier in the scheme around whether employees just needed to be told that they were being placed on furlough, or whether they needed to agree in writing that they were being placed on furlough. Again, the guidance which is operative from the 1st of July talks about an agreement and not just being told in writing. The other requirements are that the employer needs to pay the full normal hourly rate for the hours that have worked, and they need to pay at least 80% for the hours which are not worked. You may also have seen that the scheme is reducing the payout to employers starting from August, when initially employers will need to pay the employer's NI and pension, and then over the coming months the payment back to them will reduce to 70% and 60%, whilst at the same time the employer continues to need to pay the minimum 80%. Again, there's no stipulation that employers cannot increase this payment to 90% or 100% or whatever. Up until the 1st of July, there was a requirement that the minimum furlough period was 3 weeks, but the new guidance states that from the 1st of July, this is no longer a requirement. What we haven't been able to identify from the new scheme guidance is if somebody is furloughed, let's say starting the last week in June, then do they still need to be furloughed for the 2 weeks in July because the furlough started in June prior to the changes from the 1st of July, or whether the 3-week minimum period does not carry over into July? We don't know the answer to that at the moment, but I think until we do know the answer, employers ought to exercise caution and ensure that any furlough period commencing in June or before lasts for the minimum 3 weeks, even if this takes it into July. The other change you may have seen is that there was a cut-off date of the 30th of June, and in order to place somebody on furlough after that date, that employee needs to have been furloughed for a minimum of 3 weeks prior to that date. There are some exceptions around employees returning from maternity, paternity, shared parental leave, and a couple of other areas. And there are also some changes around employees who have TUPE'd across from one employer to another. And if you're falling into that category, I would suggest you perhaps take some advice on it. The other important point to note is that the 30th of July 2020 is the last day that employers can submit claims for periods ending on or before the 30th of June. I hope that the presentation has been beneficial. It's a large and fast-moving area of law, and I'm sure that there will be changes over the coming weeks to the areas that we've spoken about, and in particular over the coming months we will perhaps have some further clarity around case law with regards to some of the earlier topics which I've covered.
So that concludes our webinar this morning. I sincerely hope you found the information of use. And if you do have any further queries or you would like information on how we can help you during this time, please do not hesitate to contact me. I believe my contact details will be on the screen at the end of this webinar. So finally, once again, on behalf of everyone at Thomas Carroll, thank you very much, and I hope you have the opportunity of meeting up again soon.